What's up, everybody? And welcome in. We're back at it here another week and more Kohberger documents that we haven't dug into yet. It's going to be an interesting discussion based on where my dad and I left off in our last discussion, breaking down the grand jury documents and requests and motions to stay and what's going on with all of that. Some of our questions were answered and some of our guesses were confirmed or denied. So we're going to get into a lot of that. And of course, we're going to answer a lot of your questions, updating with Kohberger. As an outlook for the rest of the week, we will be covering the YNW Melly trial as it kicks back on tomorrow. And then we will do a couple Scott Peterson updates as we expect the state to potentially rest their case tomorrow. And we might have a verdict by the end of the week. Maybe next week. Stuff is happening. We are also planning our members only live for either the end of this week or next week. So keep an eye out for that. And a lot of new things coming to the channel in the next couple weeks. So it's going to be fun. Thank you for joining us. If you're new here, hit that like button and make sure you subscribe. We are just climbing our way to 250K. We haven't even started thinking about the fun stuff and giveaways we're going to do to that, but we seem to be getting there closer and sooner than I expected, which is always fun. And I appreciate everybody who's helping us get there. So the topic of today's conversation is going to be on a lot of the questions I've gotten on social media, which is, why is the state trying so hard to block the defense, to block discovery, to block the stay? And I want to start out by, when we get to the discovery, we'll talk about how common this is in so many cases. And the defense and the prosecution, in just about every case, there are multiple areas of discovery, whether it's documents or questions and answers, that they just will not agree on. One side will say, I did provide that to you. The other side will say, no, you didn't, or you didn't provide it in the way or manner in which I asked for it. So that is not unusual. Blocking a stay. This is kind of surprising to me that the state is filing an objection to the stay. But we're going to get into why I think they're really doing this, and not that they want to rush Brian Kohberger and his team to trial in October. We said from the jump, the state is always ahead. They make the decision to file. They take their time in gathering all their evidence before they file charges. They had time to prepare for a preliminary hearing that never happened, and eventually they had the secret grand jury. And so that to me is not a surprise that the state would be further along in their preparations than the defense. The defense has said as much to the judge, and we will see if that has an effect on the judge's decisions going forward. So let's see how we want to handle this. All right, let's get into... Hold on one second. Okay, so let's get into first the discovery. Okay, is the state trying to block the discovery? The defendant has now had to file a second motion to compel, and that's what we are going to look at to start. Titled Defendant's Second Motion to Compel. Comes now Brian Kohberger through his attorney and compels the state's answers here on some of their discovery questions. The state has provided a significant amount of discovery materials and has provided written responses to the discovery requests. However, certain requests remain outstanding. As such, Mr. Kohberger requests an order for the state to disclose the following items included in defendant's first and second supplemental request for discovery, exhibits A and B. So let's get through these. Number one, investigative reports and conclusions from all cell phone analysis, including but not limited to any analysis conducted by police agencies, FBI, CAST, team, or other Idaho authorities. So the defense is saying, you haven't given us all this cell phone data. We've heard you talk about it. We heard it in the affidavit. I'm sure the grand jury heard about how you're going to ping Kohberger's cell phone, and this forensic evidence is going to be the evidence we need to convince a jury beyond a reasonable doubt of his guilt. So what have they done? The state has responded by listing page numbers and audio video file names of information and data provided to the defense in discovery. As of June 13th, 2023, last week, counsel for Mr. Kohberger has not received any investigative reports and conclusions of the analysis of this data conducted by police agencies. So what does this mean? And what's interesting is, if we start by, this is exactly what I expected the state to do. And I've told you we have had to do this in cases where we have provided boxes and boxes of invoices and documents. And instead of picking individual invoices and documents out and copying them and sending them over, we bait stamp them and we reference bait stamp numbers in our answers. So if you're looking for a specific report and it's bait stamp number 1362, instead of pulling that out, copying it and saying, okay, here are these 6 answers, this question, these 10 answer this question in the terabytes of data that we've provided. Instead, we just provide the bait stamp number, do everything electronically. The state can have everything electronically. The defense can have everything electronically and they can find it there as well. So that is 100% acceptable behavior by the state. However, the defense seems to be stating here that although the state has given page numbers, they haven't received any investigative reports or any conclusions of the analysis. There's a couple things that could mean. Number one, maybe there are no investigative reports or what they are calling investigative reports, which can really get into the semantics that can be annoying when lawyers are fighting with lawyers. And it's like, you called it an investigative report. What we call it here is an invest, or what we call it here is a reporting of an investigation. Judges usually hate that, but it happens from time to time. Number two, conclusions of analysis. Well, maybe there is no written documentation or video or audio of the actual conclusion. Maybe that's going to be for an expert to explain. Maybe that'll be part of an expert report. So that's the question. The defense is saying you have not provided these documents. So the state needs to either say these documents don't exist or they're going to be part of an expert report, which again, I think we're going to get to later. Request number 4. All footage provided to forensic examiners with FBI used to identify the make and model of the vehicle. All reports generated related to the identification of the white Elantra. All reports, communications, and documentation related to the change in year of the white Elantra sought. CV or credentials of forensic examiners. The state has responded by listing various page numbers and file names of recordings they have previously provided. However, they do not provide any reports generated or communications and documents related to the change in year of the white Elantra or the CV or identity of the forensic examiner who identified this as the make and model of the vehicle. Okay. Another interesting question. It seems like what the defense wants to know is, how did we get on this Elantra investigation? And once we got there, how did you match make and model? When did you decide to change the name? To me, at first glance, this seems like something I would get in a deposition of the law enforcement officers. I would ask them these questions. And once they gave me my answers, I would follow up with additional discovery. Now, time is of the essence here. We've got an October trial date. We've filed a motion to stay as the defense, but we haven't gotten our answer. So I'm putting my defense hat here on. So they're trying to get this stuff as quickly as possible. They're filing their motions to compel. And if the state doesn't give it to them now, I think they have a pretty good record that if they go take a deposition and a law enforcement officer says, oh yeah, we have that here, or it's this document or that document, then now they can go to the judge and say, Judge, we didn't ask once in the request for production. We didn't ask twice in the request for production and then a first motion to compel. We asked 3 times. Request for production, first motion to compel, second motion to compel, and they still didn't give it to us. Then when we took this person's depot, they said, boom, it's right here. So that could be problematic if it does exist. And the defense is laying a good record here. Request 17, please see Exhibit A to the defendant's first supplemental discovery request for specifics. The state has responded that they are attempting to obtain this information. If it exists, the state will comply with the request upon receipt as of June 14, 2023. Counsel from Mr. Kohberger has not received this information. I forget what this is, what these exhibits are here. Again, we're reading this for the first time together. They have responded that they provided recordings of an in-person interview with FBI agents rather than a phone interview done by Moscow police. I wish I would have looked this up, because I'm wondering if this is statements made by Brian Kohberger, or if it's statements made by any witnesses or statements made by victims. This is something I will look up before our next video. Request 109, identity of FBI special agent that is a member of the cellular analysis survey team that was consulted with to determine locations of cell phone from 1112 and 1113 and all CAST certification records and training records for the involved agents. So who was actually doing this cell phone work? The state objected to this request for the reason that this is outside the scope of the discovery rule. To the extent that the state intends to offer expert testimony, it will comply with the rule. Mr. Kohberger disagrees, as this information was largely relied upon in various warrants, including the arrest warrant. Information relied upon to secure search and arrest warrants is necessary to conduct analysis of Fourth Amendment issues. Further, the entirety of the information could include materials required under Brady. Idaho Criminal Rule 16 covers broader area than the evidentiary rules of admissibility. So what they're doing here is they want the actual information about the people that worked on this. The state is saying if we call them as experts, we'll provide it in expert discovery. The defense is saying, regardless as to whether or not they're your experts, there could be information that's exculpatory under Brady or other information that we can use to poke holes in your case and to make our defense. And the judge is going to have to make a call. Does this fall under just expert testimony? Or is it broader? Requests 120 and 140, all tips received by law enforcement relating to this case. The state has provided various tips throughout discovery. So they want all the tips. And they're saying the state has provided some tips. However, they're scattered in pieces throughout the discovery, which is frustrating and can make it very difficult to figure out what they're using and what they're not using. But what they're asking for specifically is a complete and chronological list of all tips, because that has not been provided. They want to know when tips came in, how reliable they were, and we can look no further than the YNW Melly trial to see when you have multiple other people this could have been, and see if law enforcement in the state did their job in investigating those and excluding those other defendants. Because if they didn't, then that could become a potential defense. That could become a potential alternative suspect. So that's something that they want, that the state is not turning over. All recordings relating to all search warrants obtained in this matter. The state has responded that they are attempting to obtain this information. If it exists, the state will comply with this request. So they're saying, we don't necessarily have all the audio recordings for all the search warrants, but the defense says, we have been provided with a photograph of a DVD entered into evidence as item 435, labeled as SW, aka search warrant, audio. There is also a notation that this DVD was copied to county, meaning sent to the county, on January 13th, 2023. So do they have it? Do they not have it? They're saying they're trying to find it. And when they're saying a picture or a photograph of a DVD, a lot of times when things are taken in evidence, they take a picture of them, they put the picture in, they also put the DVD in. But now it seems like there's a picture of the DVD, but we don't actually have the DVD of the audio. So we'll see. There's going to be decisions the judge has to make after hearing argument. Request 164, body cam, recordings, notes, photographs, and all information collected at the autopsies by Tolson, Vargas, and Gunnarsson. The state has responded that they do not have these items in their possession. Clarification is needed. Do they exist? And are they still in the possession of another agency? Do they exist? It's like, hey, state, can you let us know? And here's the thing, 99% of the time, there are what we call meet and confers between lawyers, where before you file a motion to compel, you send a 10-day letter. Hey, can you give us this stuff? Tell me if there are issues. We heard about it in the Johnny Depp case actually a lot, and we read some of their snarky letters back and forth. But most of the time, Ann Taylor will first call Mr. Thompson and say, hey, do you guys have this stuff? And you're saying you're waiting for it to be turned over? Or you're saying it doesn't exist? And it seems like at this point, they have not gotten that answer from the state yet. So there are a lot of issues that I guarantee the defense and the prosecution have been able to work out between themselves. But there are still at least these 8 remaining things a judge is going to need to make a call. The judge is either going to need to force and order the state to comply, or tell the defense you're not entitled to this at this point. If they call them as experts, we will deal with it then. Aunt Clara said, curious, has there ever been a case where the prosecution is so adamant on not turning over anything it deems? So there's most cases the prosecution doesn't want to turn over anything the defense asks for. Most of the time, they think they deem whether something is admissible or not. So we'll see. I wish you'd live react to some of this stuff. I feel like it'd be priceless. I missed when this came through, Sleuthy. Sorry. I love the lawyer you don't know. Awesome screen name. Is there somebody in the chat, the lawyer you don't know? Does Peter have merch with words matter and definitions matter? If not, we need to write that down. Barley Hops question: are law enforcement required to sit for defense depositions, or is that what Cross is for? So this can actually be state by state, but for the most part, the answer is yes. In most states, for felonies, law enforcement, if they worked on a case, even in an ancillary level as just like doing the perimeter or signing off on a report, yes, they can be compelled to a deposition for the defense or by the defense. McSpunky: this is why only certain people are capable of being a lawyer. It's not for me, but I'm glad there are people like Peter willing and able to represent us. Definitely not for everybody. Definitely not. It's even frustrating for the people that are here. Norja: new here, post-law student here. Love this channel, Peter. Thank you. Welcome. Cellar Door: could law enforcement have alerted for the wrong year Elantra at first to make the alleged criminal feel empowered? So here's the point. If it was an investigative technique, which is what they call misinformation, or, trying to not alert the defendant that they know it's them, or make them feel comfortable so they get lazy. There's lots of different things they can do, or even lie at times, as we've heard. They can do that, but if it's in a report or something, the defense wants to know that, or if they actually thought it was a different car than it was, or different model, or different make, or different year, or different color, they want to see the progression in the investigation. Sometimes you get that, sometimes you don't, depending on what's actually documented in reports. But a lot of times, if there's testimony about it, you can find that out in depositions. Some new members here we're going to recognize: Jacob and Rebecca. Here's the lawyer you don't know, a new member, and welcome. Boss Lady and Gailey May. Alfred: he has to give up his speedy trial for these findings. No, he doesn't, and he's going to use that to keep the pressure on the state for as long as he can. But eventually, if he says, I am not ready to go to trial in October, then in order to continue that trial, he has to waive his right to speedy trial. There are some exceptions, and we'll see if any of those come up in the future. All right, let's jump to the clarification that the state wants to make about what exactly they are agreeing to give up we may have already read this. I can't remember. I know I read it on Twitter, this one before. Comes now, the state of Idaho. By and through the Latah County prosecuting attorney respectfully submits the following clarification to the state's position on the grand jury record/transcript. So there was a lot of discussion. Is the state willing to give up this, or are they willing to give up that? The defense wants this, but it seems like the state's only willing to give that. Can we come to an agreement? So this was obviously something the state felt could not be handled behind closed doors, so they had to bring it to the judge's attention. The defendant's reply to the state's supplemental response to defendant's motion regarding grand jury record and transcript dated June 13, 2023, suggests that the defense believes the state wishes to limit the transcript/record to the evidentiary presentations and list of grand juror votes. Note, at the bottom of the first page of the defendant's above referenced reply, the defense refers to the grand juror notes. Although this is likely a typographical error, the state wishes to note that the individual notes of the jurors are not available for inspection by any party. To clarify, the state's position that the record/transcript of the grand jury proceeding include everything that was done on the record. This was something my dad and I discussed back and forth. What is counted as on the record? Are we talking about jury selection, or are we talking about just the evidence that was presented and the arguments that were presented to the jury? Because that makes a difference. What is on the record? And recorded by the clerk and or court reporter, including the jury selection process. So we get our answer. They are not only going to give the arguments and the evidence presented to the grand jury, but also the jury selection process, which to me is incredibly important and should make a lot of the defense's argument a moot point. Because what they want to find out is, how was this grand jury impaneled? Was it impaneled appropriately? How did they deal with the media attention? How did they deal with all that stuff? And if you're going to get the jury selection process, then you're going to find out, what were the jurors' answers? What questions did the prosecutors ask? Did they get people that were clearly biased by the news and media who have already convicted Brian Kohberger? That's what the defense wants to know. They also want to know about exculpatory evidence and what was presented. Did they hide things from this grand jury that potentially invalidated? Well, the state's saying, we're going to give you everything. It seems like everything to me that the defense wants. Were this a situation where the grand jury was a standing grand jury that was not impaneled specifically for this case, the state would likely take a different position. So we discussed about this. We discussed whether or not this was a specific grand jury or a general one, or what they call a standing grand jury. And we didn't know until now. We heard rumblings that it was specific, but that makes a difference. Were they here deciding a bunch of different cases or specifically for this case? Well, the state continues here in their clarification. However, because this grand jury was impaneled specifically for the case at bar, the state believes that the transcript/record should include the jury selection process. So why the difference here? First, if this was about a bunch of different cases, there could be secret information or things that the state would not want this defense team to know about. Another case, a case they have not even filed charges on yet. A case that the grand jury came back and did not indict on. And other secret things during the process that Kohberger and his team are not entitled to know. That has nothing to do with Kohberger. If that was the case, they may not want to allow them to get the grand jury selection process because they could be asking questions that reference different cases. But because it was specifically about this case, they agree they're entitled to it. They get to find out how this jury was picked. In essence, the state's position is that the transcript/record begins when the assigned judge first goes on record and continues for all reported/recorded events through the discharge of the grand jury. That is basically everything. And this is kind of what I was arguing about in the video with my dad, that I think they should get everything, including picking the jury. Now, my dad didn't necessarily say they weren't entitled to it, but he was saying that he doesn't necessarily agree that that is the record of the case, which you can kind of argue back and forth. And the fact that the state added it as additional to the record of the case, you can see it both ways. The state respectfully submits that this addresses the defendant's interests in the questioning of the prospective jurors, as well as the nature and quality of the evidence presented, including whether exculpatory evidence was included as described by the defense in the first full paragraph on page 3 of their reply. Again, that parentheses, including whether exculpatory evidence was included, leads me to believe Anything the state felt was potentially exculpatory, they presented. They presented a full picture to this grand jury so the grand jury could make a decision. Now, it's obviously different when the state's presenting it versus when the defense is presenting it, but they feel like they picked this jury the right way, in a fair way. They presented evidence in the right way and in a fair way, and the jury came back and decided to indict Brian Kohberger on all the charges before them. So that is the clarification the state made. Let's get to a couple questions. John, what's more important for LE/prosecution, getting the truth or getting a conviction? Seeking justice is absolutely what they are called to do. That is what they are here for. Now, whether that rings true with every law enforcement officer and prosecutor, I was going to say I plead the fifth, but I won't. It's not. You are right. They do go for a conviction sometimes. Not that you were saying that, but in your question, that's on a person-to-person basis. But they are there to seek justice. Midwest girl, defense needs to give the alibi but hasn't. What's the difference? Playing games on both sides. I don't know. We'll see. If the judge gives them more time, he gives them more time. If he doesn't, they've got to produce what they have. Been watching you for a while. Just became a member today and already happy. Thank you. Thank you, Alfred. Alfred, let's get to a question of yours. How does he get a fair trial, though, because the media has him a convicted murderer already? You pick a jury that is not biased or colored by the media attention at this point. That's the only way you can really say. So at this point, the judge and both lawyers are trying to do everything they can to keep the jury pool as wide and open as possible. Don't present this stuff to jurors. Don't poison potential jurors. That's where we're at. Tori, Peter, as an English teacher, you can imagine me wearing a shirt that says word matter, me wearing a words matter shirt. That would be iconic. Please make this happen for your favorite hypothetical criminal. We will make it happen, Tori. We will make it happen. Norja asked, am I saying that right, Norja? Where can I buy Lawyer You Know gear? I want that hat Peter wore. LawyerYouKnow.com. We'll make it as simple as possible. LawyerYouKnow.com. Bella, can you throw it in the chat for me so he can click that link? Everybody say hello to Bella. She is working with John now for his company and will be in some of these live chats. We're pumped to have her as part of the team here. Doyle, if the prosecution's case is so strong, then why is the prosecution stalling? It's not about stalling, right? They could be, right? They could be stalling. They could have something to hide, sure. Or in any case, a lawyer does not want to give any information that they shouldn't give. You don't want to give the other side anything they're not entitled to. You don't want to give the other side anything that you think they're going to twist unnecessarily outside the rules of evidence or the rules of what's relevant in a case. So you want to play by the rules. That's really what you want to do as a lawyer. Because you can get in trouble when you say, whatever, just give them this or give them that. Because it could affect a lot of things. Welcome, Laura. Moon baby, you're wonderful and I adore you and your papa. Thank you. It's perfect timing right before Father's Day to make that happen. What's so secret about a secret grand jury? This is confusing. So it's secret to all of us. We're not going to get this information. The defense didn't know what was happening, so it was happening in secret. I mean, even the victims didn't know. So we did a whole episode where my dad and I kind of broke down what is the secret part of a secret grand jury. So I encourage you to check that out on a deeper level that we kind of dove into it. All right. So now let's get to one of the more interesting documents here, which is the state's objection to the motion to stay. And this kind of goes to the last question about why is the state, quote unquote, playing games? Comes now, the state of Idaho, by and through the Latah County prosecuting attorney, and objects to the defendant's motion to stay proceedings for the following reasons. The defendant's motion should be denied. So this is not necessarily about the fact that they don't want to turn something over, or they don't want the case to be paused, or they don't want the case to be delayed. This is not necessarily about that, but it's about following the rules and whether or not the defendant is entitled to a stay at this time. That is the point of this motion. This motion, or objection, is not just to frustrate the defense, in my opinion. On May 16, 2023, the defendant was indicted by a grand jury of 4 counts of first-degree M and 1 count of burglary. 3 days later, the defendant filed a motion requesting release of the grand jury materials under a qualified protection order, motion to enlarge time to file pretrial motions, and motion to make available the record of all proceedings under the grand jury. On May 26, the state filed its response. The state noted that it did not object to the defendant's motion to enlarge time and went a step further by concurring in his request for additional time. So the state's like, sure, take your time, do everything you need to prepare for this case appropriately. On May 30th, the state filed its response to defendant's motions regarding grand jury recording transcript and a proposed order for preparation and release of transcript and a record of grand jury proceedings with conditions. As noted in that response, the state had also provided a proposed stipulation to defense counsel on May 25th. After the parties were unable to reach an agreement as to the scope of the grand jury materials that would be subject to release, the state submitted its supplemental response to defendant's motion regarding the grand jury record and transcript on June 6th. Then on June 13th, the defendant filed a reply to the state's supplemental response to defendant's motions, addressing the substantive legal arguments that the state set forth in its June 6th supplemental response. Also, on June 13th, the defendant filed a motion to stay the proceedings. The defendant asserts that he, quote unquote, intends to contest the indictment and asks this court to stay this matter so that he may discover the grounds upon which to file the motion to dismiss related to how the grand jury was selected. In his motion to stay, the defendant relies solely on Idaho Code 2213. So this is correct. I remember from the motion to stay that he did not yet know exactly why he was going to contest the indictment because he doesn't have all the records yet, but he intends to. And he wants to discover the grounds upon which to file a motion. Is that appropriate? So these are where things cross over, and the judge has to answer multiple questions. What is the defendant entitled to, and how quickly can we get it to him? And once he gets it, then can he file a motion to stay? But what if there's an excess delay or an extraordinary delay to get him the information so that he can know what his reasonable basis is going to be? That's what the judge has to balance. And the state argues before or until he tells you what the issue is that he's going to file this motion to dismiss the indictment on, you can't stay the proceedings. So the state is not necessarily arguing that they don't want to stay or they don't want an enlargement of time or they don't want to delay the case. So the state is arguing it's not about the stay, it's not about the pause. Is the defendant handling this appropriately? Argument. Defendant's reliance on Idaho Code 2213 is misplaced. The statute provides that a party can request a stay in proceedings where there has been a, quote, substantial failure to comply with the applicable law in selecting the grand or trial jury. Under 2213, a motion to stay must contain a sworn statement of facts, which, if true, would constitute a substantial failure to comply with this chapter. Only after the court determines that a substantial failure to comply has occurred can the matter be stayed. Upon motion filed under subsection 1 of this section containing a sworn statement of facts, which, if true, would constitute a substantial failure to comply with this chapter, the moving party is entitled to present in support of the motion the testimony of the jury commissioner or the clerk, any relevant records and papers not public or otherwise available used by the jury commissioner or the clerk, and any other relevant evidence. If the court determines that in selecting either a grand jury or a trial jury, there has been a substantial failure to comply with this chapter, the court shall stay the proceedings pending the selection of the jury in conformity with this chapter, quash the indictment, or grant other appropriate relief. As the plain language of the statute makes clear, a moving party must make a factual showing of substantial failure to comply with the statute. And only after a court makes a finding that such failure to comply occurred can the court stay the matter. So here's where I disagree with the prosecution a little bit. Based on their argument, it sounds like they're saying you have to win your motion to dismiss the grand jury indictment in order to get a stay. And the defense's argument, I think, makes more logical sense in that we need a stay in order to get the information to discover what the issue is. Because we can't find our issue if we don't have the documents that are secret. And that, I think, is the nuance to these words and these statutes that the judge has to make a call on. Can the defense even figure out what their issue is with the way that this grand jury was selected? Can they? Or is the state tying their hands? That's the difficult part for me. As we sit here today, are they tying the defendant's hands and then saying that they can't stay the case because we've tied their hands? As the plain language of the statute makes clear, I think I read that already. Defendant's motion is deficient because he did not include a sworn statement of facts, which, if true, would constitute a substantial failure to comply with this chapter. Because they haven't gotten any of the information yet, right? I mean, that's kind of where I'm looking at this if I'm a judge. And again, I'm not an expert on Idaho law, so if they presented more to me with case law that showed which way I should lean, if they say, nope, you can't have a stay till you actually file your motion to dismiss and you have your legitimate reason, then fine. Rather than include a sworn statement with his motion, defendant asserts in a footnote that Mr. Kohberger will comply with filing a sworn statement of facts in accordance with the rule as soon as he has the grand jury record. By including this promise to file a sworn statement in the future, the defendant implicitly concedes that his motion is deficient at the present. Because the defendant has failed to comply with this key requirement of Idaho Code Section 2213, his motion should be denied. Defendant asks this court to put the cart before the horse, meaning asking the court to stay the case before we know if there's a reason to stay the case. That's what the prosecution's arguing. And the defendant will give the court a basis for the stay later. The court should decline to adopt this backward reading of the requirements of Idaho Code 2213, and the defendant's motion should be denied. So here's another thing I'm thinking here. Okay, just bear with me for a second because this is totally off the cuff. But just as a lawyer who's got to use the tools you have, they reference here, and this is probably why the defendants used this statute. The court shall stay the proceedings. Okay? So if you find a problem, if you find a major problem and you bring it to the court's attention, the court shall stay the court proceedings. So if this happened, the court has no discretion. They have to stay the proceedings. Well, there are many other reasons, including in the interests of justice, that the court may stay proceedings. So if in conjunction with this rule, the court feels like something unfair is happening, the state is unreasonably delaying, I'm not saying they are, but if the court found the state is unreasonably delaying, turning over the grand jury documents or quibbling over certain things because of semantics or titles or trying to make it difficult, the court can stay the proceedings. And again, a stay can be a day, it can be a week, it can be 6 months. So the court has discretion to stay the proceedings to allow the defense to get the grand jury documents, give them their 7 days to file their affidavit, to see if it's necessary for an additional stay before they file their motion to dismiss the indictment because of the way the grand jury was selected, or presentation of exculpatory evidence, or whatever argument they want to make that we heard before. So I think this is solely going to be at the discretion of the court, which is incredibly interesting to me, right? Because we're going to find out, and there's like a hierarchy. And I noticed this during the marathon that was the media's motion to get rid of the gag order or alter the gag order. The state and the defense, it's almost like brothers. It's like, I can beat up my brother, but you can't. So as the state and the defense sat in there, they're like, we want everybody else out that's not a party. Only the two of us and the judge can know this stuff, right? And the judge is like, we care about everybody's rights here, the party's rights. The state's like, yeah, we care about the defendant's right. We want a fair trial too. So keep the media out. Keep Shannon Gray out. Let's just do this us. But when it comes down to this, and we talk about his right to a fair trial, right? That is so important. We have to keep the media out because we want him to have a fair trial. Well, if we want him to have a fair trial, let's do everything we can to keep his speedy trial rights intact, which he has demanded at this point. But something outside of the criminal prosecution of these first-degree murder charges and burglary charges, this grand jury issue is outside of that litigation. So why not pause that litigation in order to keep his fair trial rights and speedy trial rights intact, stay the proceedings for 30 days, get them the grand jury information, give them the 7 days to present their affidavit, let them file their motion to dismiss, and once that's denied, which I expect it will be denied, once that's denied, then we're right back in on the speedy trial track. We've kicked the case from October to November. No harm, no foul. That seems appropriate to me in the interest of justice and within judicial discretion. I'm not saying that's going to happen, but that's what I would try to do, something like that if I was the judge. Lori, welcome. Callie got the hat cap and loves it. Me too. The hats were one of my favorite things about the new merch launch, and I bought like multiple colors, multiple different hats that we have. Cat Yarb's 7-month member anniversary. That is awesome. Azam, another reason why I'm a math teacher and not a lawyer. Happy 243,000 subs, Peter. I can't wait for the members only stream. Shout out to Nicole Wheeler, who I'm sure is gifting memberships hand over fist like she usually does. If Brian is innocent, Sammy asks, why doesn't he give an alibi and let the investigation go on? I truly believe he is guilty due to DNA and car date matching CCTV footage. Because it's just my opinion, looking into it. If he can get more time to get more support and backup and information and corroboration for his alibi, he wants to do that. If the judge doesn't allow it, my guess is he will provide what he has. Question, Peter, on another stream, someone brought up habeas corpus. If BK thinks he's innocent, could this apply? Not right now. I have no idea, but was interested. Thank you. No. We'll talk about habeas corpus on another episode. Pete did a whole video on that, I believe. Holly, how far until the next milestone for the lawyer you know? We're 7,000 subscribers away from 250K. The new goal is July 1st. I was originally thinking end of July, but it's possible. We'll see. Everybody here subscribes. We'll get really close. Brooklyn Basement. Does the exclusionary rule only apply to the defendant? Can law enforcement illegally obtain evidence from a third party to use at trial? Exclusionary rule, it seems like the way you're using it here with context could mean a couple different things. Anybody that obtains evidence illegally cannot use it for their benefit. You can't steal something and then use it, okay? Because we don't want people doing that. So if they were allowed to do that, people would be committing crimes. So it does include parties and it also includes law enforcement. But if Kohberger were to get his hands on something that somebody else obtained illegally, but he had clean hands and how he got it, meaning maybe it was like put out on the internet in public. Kohberger got it because it was public. It's not his fault and he didn't pay anybody or have anything to do with that person obtaining it illegally. He would at least have an argument he might be able to use that. And I would say, again, in the interest of justice, if it was like a video of somebody else committing the crime, let's just hypothetically say that's what it is. I think this case would be dropped, as it should, because then we know we've got the wrong guy. Even if that was originally obtained illegally from somebody else and Kohberger got it with unclean hands. I'm sorry, with clean hands. Sleuthy Goosey. Isn't everything else evidence-wise minimal compared to the fact that they already put out to jurors that his DNA is on a knife sheath? Lawyer, you know, what could be disseminated worse than that? So full transparency, that is the biggest piece of evidence to me that makes it difficult to think maybe he didn't do it, right? That's where my mind is. He is innocent, presumed innocent. But what I'm thinking is, how is the defense going to overcome that? And it's something that might not even come in at trial. Imagine early in the Murdaugh case when we said, if we were sitting here talking about it, he has blood spatter all over the shirt that he was wearing when they arrested him. If he has that blood spatter, obviously he shot a shotgun into his family. Now, he ended up getting convicted anyways, but that blood spatter ended up not even coming into evidence and not being reliable. So I think Sleuthie's point is, this stuff has already been disseminated. So what are we really stopping with this non-dissemination order? It's a balancing act, right? We don't know. We don't know what we don't know. Maybe they do have something more damning they could leak. I don't know. Crystal, could this turn into we can't defend our client because the state is holding this info back, then dismiss the charges eventually? So highly doubtful that they're going to dismiss the charges. What would happen in this situation, again, if they demand a speedy trial, the judge will either say, you go to trial and the state can't use any evidence they haven't produced in discovery, or we can continue it if you agree to the continuance but don't waive your speedy trial, gives you more time to look through the state's evidence, or you were the one that wanted the speedy trial, so you go to trial with what you have. That's kind of what the judge can decide. A lot of different factors going on. Doris, good afternoon, Peter. Great to catch your show. I'm wondering if Brian had an alibi. Is the grand jury like a trial jury? Friday, I go in for a bone marrow biopsy. Well, Doris, we are going to hope everything goes well with the bone marrow biopsy for whatever reason you're going in there. And we will be saying our prayers here as the lawyer, community, that everything goes well and comes back clean. If he does have an alibi, is the grand jury like a trial jury? So nobody presents his alibi to the grand jury. The state might not even know what his alibi is at this point because we haven't seen the actual notice of alibi filed. That doesn't mean the defense couldn't have already tipped the state off to what that alibi is, but that was most likely not presented to the grand jury, which is, I think, what your question is. Holly, do we think one person committed this crime? Well, if we are the state and law enforcement, the answer is yes, but who knows? Ashley, and you're watching Game of Thrones at 250,000, right? I don't know. Maybe we'll set up a poll. Maybe if that's what everybody wants, and we'll do that. And then we'll just have to talk. I'm sure I'll want to just talk Game of Thrones nonstop if I do watch it, but I'm a little apprehensive to dive in at this point. Okay. That is it for the documents. Was mine the only super chat? Brooklyn Basement said, I don't know what that means. So that's it for all the documents. And I wanted to make sure we got through all those, answered as many of your questions as we could, because this stuff is never stopping. It's really never stopping. And it's important to know why each side is doing this, that they're not always just frustrating the process or being annoying or trying to hide stuff or fishing and that goes for both sides. I said the same thing when the defense wanted to extend the time to provide the alibi. I'm saying the same time with the state is objecting to this motion to stay. They believe it's not an appropriate remedy at this point. So that's really kind of where we're at in the point of understanding this criminal justice process a little bit more. That's the main goal. Azam, Peter, do you remember Wayne? I thought it was Logan. Was it Lang? No, you're right. Wayne Lang. Your first ever member. I haven't seen him in the chat for a while now. Have you? I have not. I used to see him on Twitter once in a while as well. Wayne, if you're here, say what's up. But I do remember that. First member. Okay, that's all I've got for today. I appreciate every single one of you that's joined us. Hit that subscribe button if you haven't already. We've got a new outro, John said. I haven't even seen it yet, so stick around for that. And to get to know a little bit more about who I am and what I do, because we are real lawyers here. I am a real lawyer with a real firm practicing personal injury and wrongful death. And we have gotten a lot of real cases from you, people in this community that need a lawyer for a case like that. We do specialize. We don't handle everything. We just handle wrongful death, personal injury cases, catastrophic injury cases. So if you do have a case like that, we would love for you to reach out and see if we're a good fit for you. If not, would love to recommend somebody for you. I appreciate you again. Let's check out this new outro. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law. is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.